Good evening. Thank you for coming. I'm very honored to be here and always like to talk to people, not just like my client, charging consultation fees and so on, but just letting you know what are the options, and then maybe we'll see me again, come to our office and ask more questions, and maybe we'll even work on your case. Let me just tell you a little bit about how this whole evening will be organized. So I'll be talking about immigration, non-immigrant, and immigrant visas. And I will address mainly the visas for entrepreneurs, for the small companies, startups, since we're not working, I don't think anyone here from the big corporation, correct? So, and during my presentation, I do encourage people to ask some questions, but they have to be general, because we are filmed, we are on the film, so I don't want any specific questions. I came in such and such time, my visa is this, etc., etc. After my presentation, we have Q&A, and you can ask me more specific questions pertaining to your situation. That's clear, right? Okay, I'd like just to know how many people from what countries and what visas, and I think that's pretty general. So what countries are presented here? I know Russia, I know what other? India, Sweden, Korea, Turkey, Vietnam, that's France. That's it. Okay.
Jordan.
What is that?
Jordan.
Jordan. Okay. Well, there are some visas that are pertaining to one country and not another, like investor visa, et cetera, et cetera. So it helps me when I'm addressing the audience not to talk about something that is irrelevant. Okay. Now, again, very general questions. You don't have to answer. How many people here are on student visas? Okay. J1, F1 student visa. How about working visa, non-immigrant working visa, H1B, L1A, excellent. How many of you have companies here? Your own company. Okay. How many of you have company abroad? Okay. Okay. Very helpful. Thank you very much. So by immigration law, we're immigration attorney. We specialize in business immigration, so we don't deal with deportation defense, removal proceedings, criminal immigration issues. We just do affirmative immigration. We do family cases, but mainly it's non-immigrant working visa, temporary visas, and green cards, employment-based. There are several attorneys in the law firm. This is our office in Palo Alto. We also have the branch office in Moscow. It's recent, just several months. We're opening another one in Kyiv, Ukraine. And we have a presentation in Canada. We have an immigration consultant in Canada as well, in Toronto. Before I go and talk about specific non-immigrant visas, I would like to make a general observation, and I always started all my presentation, all my talk, I start with this definition of non-immigrant versus non-immigrant. All immigration law can be divided on two big categories. Non-immigrant visas, when you come to the United States temporarily, right? None of you here have green cards, correct? So you are not immigrants, you are non-immigrants. You're in this country with a temporary status, whether it's a student status or non-immigrant working visa, you're here on non-immigrant temporary visa. When at some point you decide to apply for the lawful permanent residence, for the green card, you started an immigrant process. So my whole presentation today will be divided in two parts. I'll talk about non-immigrant visa first, available to you, or how you can change your status from one to another based on the change of occupation, change of employer, change of your position, even change of your geographical location. And then we'll talk about how you can change your status or adjust your status. That's the term of art, to lawful permanent residence. An adjustment of status brings you to the green card, which is for some is an ultimate goal and for some not. Yeah.
Will you be sharing the slides?
I will be sharing the slides, absolutely, yes. And I believe the YouTube video will be available as well, so you can connect the image with the voice. For the non-immigrant visas, I will start with the visas pertaining to the small companies, startups. And I know that many of you heard about so-called startup visa, right? Startup visa, which been talking about, I think they will be talking about for 3 years now. It's still not to be seen, and I will believe in it when I see it. So for now, for the startup companies, we are still using visas like H-1B, L-1A, investor visa, etc. So let's start with the visa H-1B that's called H-1B specialty occupation. The H-1B visa is a very simple and popular type of visa. And any of you guys here are on H-1B visas? Okay, so lucky you. Did you win the lottery? That's what happened, right? Or you just transferred from one company to another. Let me explain. So there are 65,000 H-1B visas available for the whole country. With the economy booming, this is definitely not enough. So this year, the first possible week for filing for the next year H-1B, for 65,000 visas available, there were 233,000 applications filed, H-1B petition. So obviously there were only 30% of the applicants were even able to participate in the H-1B lottery. H-1B visa is a very simple visa. The beauty of it is that you do not have to prove that you're extraordinary. You do not have to show that you have a company abroad, like with many other type of visas. You do not have to show that the company has money, which is another myth surrounding H-1B. All you have to show is the petitioner. The petitioner is the company. There is a company. It can be a small company. It doesn't have to have any revenue going. All it has to have is the office. It has to be not a virtual office, not a co-working space. It has to be a real office space with lease and sublease. You have to have a business plan, and you have to have corporate documents showing that there is a company. Registration with the Secretary of State, articles of incorporation, or articles of organization if it's LLC. So this is all you have to show for the company. So if we are talking about H-1B for a small startup, it's absolutely possible. There is no need to show that the company is making any money or has investment. Do not wait for investment. Do not wait for the angel to give you some money. If you have a product, if you want to start your own company, if you need this company to apply for you for the H-1B visa, it's absolutely possible, okay? For the beneficiary, all is required is that he or she has a bachelor degree in specialty occupation in some specialized field, or the equivalency of a bachelor degree. So the equivalency evaluation can be done by an accredited company here in the United States. We work with many companies like this, and they know what they're doing. So if you have enough years of experience, you do not have to have a bachelor degree. They will evaluate your experience towards the bachelor degree, and you can get your H-1B visa. Position, of course, also has to be a specialty occupation, which means if you are a manager for Victoria's Secret, that's not a specialty occupation. If you are a manager for the IT company, that's a specialty occupation. So the position has to be such as require a bachelor degree in a specialized field. Now, those of you who have H-1B visa know that you participate in the lottery only one time, right? The first time you apply for H-1B visa, you participate in the lottery. After you got it, then you can transfer from one employer to another anytime within the next 6 years. So you don't have to have on April 1st every year wait again for the lottery. Again, you got your number, you are in the system, you have one of the 65,000 H-1B visas available. So now if you want to change your employer or you want to get the concurrent H-1B, I'll be talking about that too, you can do it anytime. You don't have to have April 1st or October 1st, the beginning of the fiscal year. That's clear, right? So again, when we're talking about H-1B, it doesn't mean that you have to have H-1B for 3 years. By the way, the H-1B, the maximum for the H-1B1 increment is 3 years, right? And you can extend it for another 3 years. The maximum amount of time you can have an H-1B visa is 6 years. So let's say you have an H-1B for the company, relatively big company, and then you decided, okay, I also want to work. My friend asked me to work for his startup, but it's not enough money. So if I leave my employment and go work with him, I mean, I can't afford full-time employment with a startup. I'm going to probably be working on equity. So what do? You can file for concurrent H-1B. Your friend, who is a startup owner, can file for the concurrent H-1B part-time. So not only H-1B can be concurrent, it can only be part-time as well, as long as you have some accumulative amount of money that will not put you on the street. For example, if you work for 2 startups and each startup pays you one pays you equity, another pay you for 5 hours per week, right? And prevailing wage is high, so it's a small amount of money. Immigration services will never approve such petition. Why? Because you are in a danger to becoming a public charge. You're not making enough money. You're not making minimum salary, minimum prevailing wage. You'll be on the street and you'll become a public charge. We don't want it, right? So what's going to happen? They will deny your concurrent H-1B petition if it's only for 5 hours. If you have a full-time employment, if you work for Google, Facebook, Applied Materials, whatever the company is, and then you secured the concurrent H-1B, it can be for a very small amount of time, right? So it can be only for a couple of hours a week. But now you are legally employed for the second company. Either it's your company or startup. This concurrent H-1B is doable. Only if it's a general question, I'll take it, just for efficiency.
It's a general one.
Sure.
Do I need a mic? So I understand that the startup has to be started by a citizen of the country. I cannot start the startup myself. And when the citizen of the country has started the company, then he can issue a concurrent H-1B visa for me so that I can continue to work at my established company and spend a few hours at my startup.
Okay, good question. Thank you very much. The reason, let me explain. The reason I ask people to ask questions while I'm talking, well, first of all, it establishes good rapport with the audience. And the second, I realize right away what people want to hear and what is not clear from what I'm talking, because for me, a lot of things I take for granted because we attorneys deal with these issues every day. So, wrong. You don't have to be the US citizen to start the company. Anyone can start the company. If I come as a tourist, if I come on visa waiver for 90 days, ESTA, like some countries can do, I can actually open the company. I don't have to be the US citizen. I don't even have to have the legal status. I can't be illegal. That's correct. I mean, I'd rather not be illegal. But I have to have non-immigrant visa. I can be tourist. I can have no visa at all. All I have to do is to register my company. It can be LLC. It can be C Corp. You can't open S Corp because you're not a resident of the country. But C Corp and LLC, anyone can open it. Anyone can be the owner of the company. And as long as you're not working for the company, you are not in violation of any immigration law. So you can be on the board of directors. You can, again, own the company. And your company can apply for you for the concurrent H-1B. Having said that, I'll tell you right away is that if you are the only owner of the company, if you're the 100% owner of the company, you will not be able to prove to immigration services that you can establish employee-employee relationship because you cannot fire yourself, right? So what you have to do, you have to have a board of directors other than you. You have to have 2 other people at least, right? So you can vote on whether, oh, you're not performing, we're going to fire you. So in this case, even if you have a majority of share stock of the shares, you can still be fired or reprimanded for not performing your duties as CEO or CTO or whatever the position is. Okay, so again, you don't have to be the citizen or even lawful permanent resident to open the company here. For example, you have a bright idea working for Google, right? You suddenly have your own bright idea and you want to develop it. So where is the borderline when you can sit in the kitchen thinking and coding, and then suddenly you decide, okay, it's time to actually start working for my new startup and get concurrent H-1B. When you start thinking about gainful employment, and gainful means you want to market. At a certain point, you want to do PR and marketing. At a certain point, you need to hire another engineer. At a certain point, you need to do something like which will qualify as an employment. At a certain point, you want to start talking to angels and seed investors and ask them for money. And they don't like you if you have your card with Google on it. They're like, why are you here, right? So when you start publicly holding yourself as the officer of your startup or your friend's startup, that's when you come to me and say, Yana, I need concurrent H-1B, and I'm going to help you, okay? And again, it can be for smallest amount of money because you have your full-time employment, provided you still have your full-time employment, right, with the, your daytime employer. And at the same time, you can file for a concurrent H-1B for 5 hours per week, and that will be fine because you're not going to be on the street because of the employment with Google, okay? Only if it's general. Go ahead.
So in that case, should the person disclose to the other company, in your example, Google, that they have a concurrent H-1B?
Can you repeat the question so everybody else can hear it?
In the example that you gave, should the beneficiary disclose to Google that they have a concurrent H-1B?
It depends. From the immigration point of view, you don't have to. But if you have some kind of non-disclosure agreement and in your employment agreement, that's different. From immigration point of view, you don't have to. But if you're working in the same field and working on the, like if you become competitor to whatever, and you have, again, you need to, the answer, let me back up. The answer is from immigration point of view, no. But from the employment point of view, maybe. It depends on your employment agreement and non-disclosure, et cetera, et cetera. Okay, so what's the question?
Okay. So if I understand you clearly, 3 people in a non-immigrant visa or H-1 visa or whatever can get together and start this company, right? And the company can issue a concurrent H-1 visa like for
Absolutely.
1 or more.
Correct. Correct. Correct.
And you don't have to lose your current job, right? Is that what
You don't have to lose your current job. You may or go part-time, but we'll talk about in detail. So, okay. So I guess let's move to a different non-immigrant visa because I think I covered in general what H-1B is about. So if you don't have H-1B and you are thinking of starting the new one, good luck because the lottery is getting worse every year. And the numbers are not getting bigger. So we're still going to have 65,000 most likely next April. And April 1st is the first day when you can apply for October 1st, which is the beginning of the new financial fiscal year, correct? So on April 1st, that's when there is the first day, and you have 7 business days, according to regulations, to apply for the H-1B and be in the same pool. The lottery will be from the same pool, right? So the previous year, we have 45–50% of our petitioners won the lottery. This year it was only like 30. So next year it's probably going to be less. So you have only 1 day, April 1st, to apply for this visa. And even in that case, you have only 1 in 30, 1 in 4 chances winning. So it's really not the best. If you very, very structure-oriented and you can't depend on winning H-1B. That's what I'm trying to say. You always have to have plan B, plan C, or anything else. So again, because we're here in Silicon Valley, because there is a huge amount of talent here, I start after H-1B, I usually go to other options. And other options are O1, alien of extraordinary ability. And I don't want you to be scared of this terminology because many of us are extraordinary and immigration may agree with you. You'll be surprised. There are 4, well, let's say 4 large areas there where you can prove extraordinary ability. It's not just everywhere. It's art, athletics, business, and science and education. So when I'm dealing here, being in Palo Alto, I live in Palo Alto, I work in Palo Alto, all my clients, they are obviously in the tech world, most of them, or universities. Stanford is next door too. So we're talking about mostly extraordinary ability in science, technology, and business. And being an entrepreneur, having a patent or patentable product or some new product will right away qualify you for so-called original contribution. Not right away. We will need to present it in the right way. We need to prove that it has significant impact on the field of endeavor or future significant impact. But again, you don't have to have a Nobel Prize to be an alien of extraordinary ability. You need, again, to come to our office and see. We go through all criteria. There are 8 criteria. You have to meet 3 to qualify for this visa. O1 is available any day of the year. You don't have to wait for April 1st. Well, the reason it's available because the quota is never reached. There are a lot of extraordinary people, but not a lot of them go to immigration services and apply for O1 visa. So the quota is never reached. You can come any day of the year and say, Yana, or any other attorney, I would like to try to apply for extraordinary ability. Can you look at my resume? I think I may qualify. And you may qualify because if you have publications and presentations or posters, conference posters, you may have 1 criteria met. If you have some awards or your startup or your work have some award or you have fellowship and scholarship, but those are tricky. But still, that's the second. Awards is the second criterion for O1 extraordinary ability. If somebody wrote about you or your work or your company, and in online or something, Regin?
Yeah, it's related. When you say like the patent, can you hear me? When you say the patent, like if it's patent pending, does it count or it has
counts,
to? It counts.
Something is
Oh no. And the publication, I mean, it's so easy to get published.
Okay, sorry to interrupt you.
Yeah.
Can I just finish?
Sure.
I thought something is malfunctioning.
Oh no.
So,
Okay.
Okay, so I was talking about awards. So awards, if you have any kind of award, I'm not talking about the Olympic Games in your elementary school. I'm talking about some award in your field of endeavor. If you work for the company and you had a key position or important position in the company, especially if it's a company like Google or Oracle or Facebook, that may be a third criteria, key position for organization of distinguished reputation. I've done O1 for very talented engineers who had one or two, even one pending patent, and had their own startup just starting, and then worked for Google and Facebook, and we won O1 extraordinary ability for somebody like that in technology and business field. We usually do this interdisciplinary O1, and they work. Whether they work because Google files a lot of them, and Facebook and Amazon, I don't know, but they do work. If you have critical role, that we went high compensation or salary is another one. If you judge the work of others, if somebody actually invited you to be on the panel in the conference or as an editor of some magazine or startup publication, that also counts. So there are 8 criteria, and we can go through this, and you can take the slides and look at them at home, and you need to meet only 3. So again, don't be shy. If you want to have me diagnose you for the O1 extraordinary ability potential, send me the resume. Let's talk. We may have a case. O1 as H1B given for 3 years. And again, as with H1B, you have to have the petitioner. You cannot just come and apply for O1. I'm extraordinary, give me the visa. You have to have the petitioner. You have to have the employer. Okay? So again, if you have the product, right, and H1B is not available, and you are not an H1B, so you have, let's say you have a student visa, or you came as a B1, B2 visitor, and that's a very common scenario when a very, very smart, very talented whiz kid from Romania comes to my office and he says, Yana, I have the product, it's cool, I'm sure I'm going to scale. I just need the visa. What do we do? Well, we help him to open the company. He can open his own company. He will need a good business plan, and he will need to show that he did a market analysis, cost analysis, some financial trajectory, and then he will, the company, his own company, would apply for him for the visa of extraordinary ability if he is qualified. And those whiz kids from Romania will qualify. And I help them to win the O1 visa. And what happens, he's in the country, for 3 years, working on his product, trying to get money, and he's legally employed for his company. Okay? And the good stuff is O1 doesn't have prevailing wage. For H1B, you have to have the prevailing wage, which is determined by Department of Labor. So let's say you have a software engineer in Santa Clara County, and it's level 1. Even for level 1, you have to pay 80, 90,000, and it's a startup. How are you going to do it? Well, one way to do it is to hire him part-time, right? So then you can pay less. With O1, you don't have the prevailing wage. If you say, I'm going to pay him 20,000 per year myself, right? It's still fine because there is no prevailing wage determined by Department of Labor for O1 visa, right? You cannot pay yourself less than 20,000. Why? Because you're going to be a public church. You're going to be on the street. So you cannot pay less. So immigration will not approve the O1 petition for less than 25,000. Any questions about extraordinary ability? General.
So in the case of an established company and a startup, let's say the established company satisfies the prevailing wage criteria, does the startup have to worry about satisfying the prevailing wage criteria as well?
Exactly.
In the case of concurrent H1Bs?
Absolutely. Concurrent H1B. H1B, whether it's concurrent or whether it's not concurrent, you have just one H1B, 2, 3. Every time, every employer applying for the H1B on behalf of somebody has to satisfy prevailing wage requirement. Again, if you're a startup and you understand that you cannot pay your marketing manager $150,000 per year if you're in Silicon Valley, your option in this case may be to hire him part-time. And part-time, you are saying, for example, this person will be working for me 10, 25 hours per week. You're given the fork of 10, a range, right? 10, 25. So by regulations, you have to pay at the least amount, so for 10 hours per week, which is, again, $25,000 per year. So if you hire somebody for startup as a marketing manager, and he's not full-time, he's part-time, 10, 25 hours per week, you're paying him $20,000, $25,000 per year, as opposed to $150,000 per year. Make sense? Okay. Okay.
My question was, does the equity count towards compensation? If
It may. 10% may not be enough, but it may count toward compensation. It can be combined, salary and equity. It can be, but it has to be vested. You understand, right? So, like,
yeah.
Yeah. Go ahead.
But you still have to be in an employee relationship. So even if that equity can't be majority equity, is what you're saying.
Yes. Correct.
Okay.
And then again, it depends. It depends.
Case by case.
Case by case,
But
exactly. Sometimes they even count commissions. I have a lot of investment people from Eastern Europe specifically, and immigration is very shy on counting anything but remuneration, salary, but different combinations.
Okay,
of course.
but case by case is
by
possible.
case, yeah. Mm-hmm.
I have two questions very quickly. What's the validity period of O1 visa, and what if the company succeeds? If there's a validity period, then what will the person do? Will he go back, or can he convert it to full-time residency?
The company succeeds in terms of what?
I mean, in H1B, there is a validity period of 3 years, and
6 years
there's a
together,
cap
total.
of 6 years. So if the same thing is the case for O12, you come here, found your own company, progress, and then after, I don't know,
Good question.
if there's a cap.
Correct. This is a good question. So yes, well, first of all, you can extend O1 indefinitely. There is no 6-year limitation on O1, so that's a good thing. But nobody does, because there is an extraordinary ability green card. And I will talk about it when I start talking about, remember the second box of the immigration law, immigrant visas. So the EB-11 is alternative, immigrant alternative of O1 non-immigrant visa. So we are talking about same criteria, but that's the petition for the green card. Okay? So at certain point, you can extend O1 indefinitely again for 3 years, increments of 3 years. But at certain point, you can apply for the green card. You can apply for the green card right away, and I'll be talking about it as well. Okay? Yes, and then let's move to another.
Right.
Yeah.
So I believe if somebody has a stock component to his salary and the stocks are not yet vested, in that case you cannot use it for a
For
O1.
remuneration.
But
Correct.
if the person has spent 2 years in the company and half his stocks are vested, then you can show it as a cash component, can't you?
Right, but again, this is very specific question, so let's leave it later so we don't dwell on this. We can go through all criteria specifically at the end, or just approach me later, okay? This is a very technical question. So let's talk about the next non-immigrant visa. That's also a good option for startups, but again, there are some caveats. L1A or L1B visa. L1A multinational executive and manager, L1B specialized knowledge visa. This is intra-company transferee visas, which means that you have to have a company abroad in order to transfer people from that company to the company in the United States. So in this scenario, you have to have 3 main criteria met. First, there should be a qualifying relationship between 2 companies. Say you have a company in France, and you worked for that company in managerial and executive capacity for L1A, or in specialized knowledge for L1B for 1 calendar year out of the last 3 years prior to entering the United States. And so that's right here. We have 3 criteria. Did you hear them? Qualifying relationship between 2 companies. managerial or executive capacity, second criteria. And third, 1 year working for the company on a payroll, okay? Not like a contractor, not like a freelancer, on a payroll, okay? For the company abroad for 1 year out of the last 3 years prior to entering the United States, okay? What is the qualifying relationship between two companies? Parent and subsidiary, right? Or affiliates of the third company. For example, there is a holding company somewhere in Netherlands, and that holding company owns the company in Russia and the company in the United States. That's the qualifying relationship. Ownership, by ownership. For example, I own the company in Moscow and 100%, and I own 100% or the controlling package 51% or more in company in the United States. I have a control over the company in the United States. I have control over the company in Russia 100%. That's a qualifying relationship. Again, that can get really technical, so I can talk more when you have specific questions. But since, again, some countries, like let's say Russia, does not have the multinational treaty between Russia and United States, and hence we don't have E2 visa with Russia. That's the only way for the entrepreneur in Russia to open the office here and to transfer his executive, his managers, and his specialized knowledge people like software engineers and so on to the United States. So that's the type of visa that's somewhat similar to E2 visa, which is investor non-immigrant visa. We'll be talking later, but it differs, and it's for some countries that's the only visa available in this category. Okay, go ahead.
If during my first 3 years period my petitioner stopped its activity or I was fired, what
in abroad?
No, being here.
Okay.
I have H-1B. My petitioner stopped its activity or I was fired. What alternatives do I have, and how much time do I have to use those alternatives?
That has nothing to do with L1A or L1B visa.
No, H-1B.
That's right. I wanted to hear the question about L1A visa. Yeah, we will get to this point, but that's a good, if you don't mind, I can answer this question. We're in a little bit different mindset right now, but let's get back for a second to the H-1B visa. So let's say some of you are on H-1B visa and you were laid off or fired, or because a lot of employment contracts are at will, right? So at a certain point, you are let go. So what are your options? Your option is to find another employment if you want to stay in the country, and you can transfer your H-1B from one employer to another. And if you do it fast enough, you can actually extend your status. You don't have to change your status, you extend your status. But if you waited or you did not file your employer fast enough within 2-3 months, you can still get the H-1B transfer, but you will not get the change of extension of status. You would have to leave the country and re-enter an H-1B visa. And again, that's very important to understand. So let's get a little bit back and talk about status versus visa. Would you like to do you understand visa and status? These are two terms of art for immigration purposes. So you have your passport, right, your foreign passport, and there is a stamp, J1, H1B, F1, visa stamp on your passport. This is visa stamp, right? You enter the country, and you enter the country in J1 status. Now you have J1 status. You have a J1 visa in your passport, and you have J1 status. So your J1 visa can be for 18 months. But your J1 status, when you enter, the officer will give you 18 months because that's what your approval for J1 visa stays, right? But if, for example, you have B1, B2 tourist visa, it's usually multi-time, right? So you can go 3 times, 5 times, whatever you want. So, but it's for 10 years. So if you enter with the visa stamp B1, B2, you cannot stay in the country for 10 years because your status that is given to you when you enter the United States is only for 6 months. So that's the main difference. So the visa stamp says 10 years. You enter your status, B1, B2 status, for 6 months. And sometimes, like with J1, it can be the same. It's 18 months. For B1, B2, it can be 10 years versus 6 months, right? So you have to be careful. If you entered with B1, B2, don't stay here for 10 years. Nobody gave you authorization you're authorized to stay whatever the Customs and Border Patrol officer at the port of entry told you and put on your stamp, right? So usually there is a date. And the date for H-1B, for example, those of you who are on H-1B, it's usually the approval of your H-1B, the extension, right? Unless your passport expires before that date. But if it's some other type of visa, you have to be careful. You have to be careful what are you giving, because your status is defined by the date in your passport. So that's clear, the difference between status and the difference between visa. So in this case, so the gentleman asking, what if I've been fired or laid off from my employer? So he's out of status now because he's not employed by the country, but by the company, but he's not unlawfully present because he's still authorized to stay in the country. So he's not accruing unlawful presence for the purposes of being banned from entering to the United States for 6 months if it's 180 days, or for 3 years, or for 10 years. But he's already out of status. So next time he goes to Russia, he will be asked extensively in the consulate why he stayed for so long, like for 2-3 months looking for employment, for example. And he would have to come with some wonderful explanation. Like, I've been looking for employment, here's my resumes that I sent, here's my interviews that I went through, I've been closing my bank account, so he has to have a good explanation. And the officer, the consular officer at the port of entry cannot prohibit him because he's not banned from entering the United States because he was not unlawfully present, okay? Well, there is a dispute among the immigration attorney whether the fact that the H-1B was withdrawn by the company kind of eliminates your status. And now you are on the constructive notice and you have to leave and you're accruing unlawful presence. Well, again, my point of view is that you do not, but again, there are some attorneys who will tell you, which I will do too, do not stay and hang out here for 5-6 months. If you cannot find your employment in 1-2 months, you should either leave the country or change your status for something like a student visa. So again, you can go to school, get I-20 form, and change your status from H-1B to a student visa. That's one of the options. Or you can leave the country and continue looking for employment from abroad and then re-enter an H-1B, because you don't have to participate, and this is important too, in the H-1B cap lottery. Again, one more time, if you have H-1B, if you won this H-1B lottery once, for the next 6 years, you can leave and go and get another H-1B anytime. That clear? That's a little bit technical, but that's clear, right? Nobody has misunderstanding about this part. So if in 2 years you find employment, you don't have to wait for April 1st for the new lottery. You can just apply anytime and get the H-1B visa stamp and approval, yeah.
Just a clarification on your last point.
Uh-huh.
Even if your H-1B
Expires,
you
yeah.
cannot reapply. You can renew it within next 6 years. Is that?
No, if you had the 6 years of your H-1B, so you have a 6 years of H-1B, then you need to leave a country for 1 year, unless you have a labor certification filed 365 days prior to the expiration or I-140 approved. And I'll talk about it.
If your H-1B is approved only for 2 years and it expires, would you have to reapply again, or you can renew?
You have to reapply, you can leave the country, but then again, if it's only 2 years that you've been in H-1B status and you left the country because you have something else going on in your country, but in 3 years you want to re-enter again on H-1B, you don't have to participate in H-1B cap.
Okay.
You can just apply for the employer and say, I already had H-1B within the last 6 years, so I would like for you to petition for me for the H-1B, and you can do it anytime. I'm not the cap H-1B. Okay.
So let me understand this last thing again. So your company fired you and they stopped paying you, but they didn't cancel your H1. So let's say in a month time you find another job. So they are filing for an H1 transfer at that point, but they would look for the recent pay stub, which is like a month old.
That's correct.
So isn't that a problem?
It's a problem. For 1 month, again, this is a lot of immigration cases. It's almost like anecdotal, right? So for me, if the pay stub is 1 month old, I've seen extension of status approved, no problem. If it's 2 months old, you may be in trouble. Most likely they will approve your H-1B if everything is correct, but they will not approve extension of status, and you would have to go abroad and re-enter an H-1B. You will have to go to the consulate. And again, if you already had H-1B visa stamp on your passport, you may not have to go back to your home country. You can actually try go to Mexico and Canada, the U.S., provided you have visa to go. Mexico usually, most countries don't need a visa, but for Canada you need a visa to enter the country, right? So you can go and try first at the U.S. consulate in Mexico or Canada if you have visa, and if you don't succeed, then you go to your home country and try to get H-1B there. So you have like several attempts, okay? Yeah, let's one last question and that let's.
This is actually about L.
Okay, let's get back to L, okay? That's actually a pretty cool visa, especially we will talk later about the green card, which is multinational executive manager green card, is a very sweet deal.
So I know you might go into further depth about what the employment abroad conditions mean, but I'm going to ask anyways.
Go.
So does that mean you have to be also if you're being paid from the office abroad, you're getting your benefits abroad, but you're physically here?
On H-1B status or just as a B1 business visitor?
OTP status?
No.
No, that's not possible.
Not a good idea. So, okay, it is possible, but not in your case scenario, okay? So, for example, if I am VP of business development of some company in Ireland, right? And I have to travel because of business to the United States. So I can go back and forth and spend half of the time of this year working for Irish company. I can spend here in the United States because I'm a business developer manager or VP of business development, and I work here and there developing business. But I'm paid, I'm on the payroll of the company in Ireland, so that's possible. But I'm coming here on B1 business visa, or I'm coming here visa waived, just to attend some networking event, or to come to my lecture, or to negotiate some deal. But I'm not working here, I'm not employed. I'm doing something, but I'm still paid in Ireland.
Okay, so the condition, it doesn't necessarily necessitate physical.
It doesn't have to be physical, but if you're here on some other status,
then that's when it's wrong.
That's impossible, right? Right. Or you can travel anywhere else. You don't have to be in the country. It's the same mentality. So let's get back to L1A, L1B. There is no prevailing wage. Remember, H1B has a prevailing wage determined by Department of Labor, not so L1A, L1B. L1A, multinational executive manager, I talked about it a little bit. Let's talk about specialized knowledge. So specialized knowledge, software engineer, but not just your regular software engineer, junior, who knows C++ and some very basic stuff. This is somebody who is working or worked on some kind of proprietary software that your company is working on. So that is the lead engineer who is involved in building your software or building your product. So I cannot bring you L1B software engineer if he was just hired by the company, worked there for a year, doing some very junior task or programmer. It has to be a specialized knowledge applicant or beneficiary. Does it make sense? So it used to be, in fact, it used to be easier to get L1B visa a couple of years ago, but then the regulations, the guidelines have changed, and we ended up with the pretty high standard for specialized knowledge. Again, if you have somebody in mind that you want to transfer from your company abroad to the company in the United States, we can talk in details about it, because the standard, again, changed, and it's pretty high now, okay? So a little bit about the timing. So L1A, total 7 years, a period of L1A, the period of L1B, 5 years. That's, you can extend it, and you can come for 3 years and extend an increment of 2 years. Very important to note that there is such a thing that L1A new office. So the person who comes here, opens the company, and it's just embryonic company right here, will not get 3 years of an L1A, right, like a big company. He or she will get only 1 year, and it's called L1A new office. And I will not have a big problem getting a first year L1A, because Immigration Service is actually pretty generous. They're saying, okay, here's 1 year. Let's see what you can do with it. in 1 year, that's when it becomes challenging. In 1 year, the immigration services will want to see what have you done in 1 year. And that's when they want to see that the business is developing. And you don't have to show the money, you have to show employees. And that's even tougher. Because the main criteria that the business is working, right, that you guys are doing something, is that you have people, you have work. So I would say 4 or 5 employees on your payroll in 1 year after L1A new office extension, that's what immigration services wants to see. That's why it sometimes becomes challenging, especially if you have the companies, they just got funding, couple of $1 million, came here, got L1A, and I will tell them, in 1 year, I want to see 4 or 5 employees on your payroll. You have to be ready to hire some sales team, even if your engineers are abroad. Be ready to have 4 or 5 people, not just you and another engineer. And guess what? $2 million gone very fast. And they don't have people. And we can't extend L1A. And all these resources, money and time, went for nothing. So just be very careful. Go ahead.
Those 4 or 5 employees, do they have to be citizen, permanent residents, or?
Anyone.
But they have
Not
to be.
illegal workers. But yeah.
But they have to be physically present, cannot be.
Physically present.
Okay.
Right. Right. Here. Thank you.
This branch in the United States, I will go to work. Does it has to be established since a long time, or can it actually come with me when I?
Well, that's what I was talking about, L1A visa. Yeah. So you have the company in France, right? And then you want to open the company here. So you opened the company yesterday and came today. That's fine, as long as you have a good business plan and you have the office. And 2 years ago, you could have a virtual office. But again, guidelines have changed. And now immigration will take only office, like a physical office, and it can be the house, because we all have Google Earth, and they look at Google Earth. And they know it's not it's residential area and cannot be office, right? So it has to be lease, sublease. Sometimes floor plan has to be shown and pictures. And it has to be tiny sublease. So for example, you can sublease a desk. Or you can. I mean, you don't need more than that, right? You're not coming yet. Yeah. No. Co-working, no. Co-working depends. There are some co-working spaces. For example, if there is a big room with bean bags, bags, right? So, and you're coming with your laptop, that's not a good co-working space example. But if it's a co-working space that you have your cubicle and there is some kind of contract, and I usually review this contract again, case by case, those may work. So you have to have that. You have to have a company, which is LLC or C Corp, and you have to have a business plan, right? So that's the minimum you have to have. And then you have to show that there is some kind of, if you are buying shares, again, of ownership, it's more technical. For example, you own the company in France, so you are saying, I'm the only shareholder of the company in the United States. So you need to show sub-capital movement to the United States, no matter how small, but I mean reasonably, right? So like you are buying shares. You can't just show immigration certificate of shares that said, oh, I own it. They will need to see some money invested in the account. Same with LLC. So that's how new the company can be, and that you are coming to establish the company. That's why I'm talking about 1 year, because they say, okay, here's Orel, here's 1 year, right? Do with whatever you want. And you have no money, or you have this, like, I don't know, like, even if you have 2 million, trust me, like you have 2 million and you say, I'm gonna scale in 1 year, 4 or 5 employee, Yana, immigration, no problem. And then in 6 months, you realize that there is no business logic. It's so business illogical for you to start hiring people. Doesn't make any sense. You can spend this money on buying users instead of paying people you don't need here. So that's when your business logic will not make you good favor in terms of meeting the standards of immigration services. You don't need these people. You have to show them. You have to show. There is no way to show that your business is growing only because you're buying users. That's not good, right? You need to show people who pay taxes to the United States, who right. So that's when L1A new office becomes tricky. You have to have good cushion, or you have really believe in your product that in a year you can really take off, and if not scale, that at least like get another million, get going. And it's really worth it because the green card in the category of multinational executive manager is a very, like I said, very sweet deal. You don't have to go through the Department of Labor. Then this priority category, the same as extraordinary ability. Yeah, so it's interesting how it works. So I will talk about it, about green card later. Okay, did I answer your question? Okay. Spouses. So if you have spouses, they will be L2, right? So L1A, L1B spouses are L2. And again, this is different from any other visa like O3 or H4, dependent on H1B, because L2 can work. So that's a good deal. So for example, you came here, you are executive, you are the first employee of your company. Your wife can be the second employee of the company, provided she's in the same field. Okay, so because she or he can get the employment authorization in 3 months, you have to apply for it. I can talk a little bit. Should I talk about this green card now, or you want to wait? Because we're running out of time. So let's talk about EB-13 very quickly, and because that's important. I know I'm running out of time. So EB means employment-based, right? There are 4 ways to get the green card, a lawful permanent resident in the United States. 4. Political asylum, through your relatives, you're getting married, or your parents are U.S. citizen, or your children 21-year-old or older. So this is second, so relatives. Political asylum, relatives. The third one is employment-based and lottery. Okay, lottery, visa lottery. You can play every October, November. The result will be in May. So we will be talking about employment-based way to get a green card. And because it's employment-based, it's EB. That's the abbreviation. And there are 5 employment-based categories: EB1, EB2, EB3, EB4, EB5. So EB1, first preference. It's first preference, priority workers. You don't have to go through Department of Labor. You don't have to show the shortage of occupation. You go straight to Immigration Services and you say, I am priority worker. Or your petitioner, the company says, he's a priority worker, give him the green card. There are 3 subcategories. EB1-1, this is alien of extraordinary ability. EB1-2, outstanding researchers and professors. And EB1-3, multinational executives and manager. And again, when I submit EB1-1, this is a huge package of documents, right? And EB1-1, EB1-2, the same. And multinational executive and manager, it's the same criteria. You have to show that there are 2 companies with qualifying relationship, that you are executive and manager, and you worked 1 year for the company abroad out of the last 3 years. That's it. And you're a priority worker in EB1-3 category. So that's really, and if you are a new company, however, and you have this only 1 year, you cannot apply for the green card immediately. You have to wait for 1 year, okay? That's the only difference. So the reason I mentioned that, because again, in comparison with H-1B and some other visas, L-1A give you a very good perspective to the green card through the multinational executive and manager green card, okay? So we are clear on that. E1, E2, treaty investor and treaty trader visa. Again, 80 countries, not all countries, have this type of treaties signed with the United States. And if you go to the Department of State website, there is a list of countries. So all you have to do, you have to type the country. For example, you type Israel. And then you type what reciprocity schedule. It's called reciprocity schedule. You look what type of visas and for what period of time you can get. And if you look E2, Israel does not have E2 visa because Israel did not sign the treaty with the United States, right? So if you look Italy and you look E2, you'll see that yes, Italy signed the treaty about E2 visa with the United States, and the period of time you can apply for E2 is 5 years, and you can extend it multiple times indefinitely, okay? So that's a 2 visa. There are again some, we can talk about, you can ask me a question, it's more specific type of visa. So if you have any questions in our Q&A part, because I'm out of time completely, but we can talk more about E3, which is the dependent, and dependents can work. We can talk about marginal investment. You can talk about what's ET trader issue and E2 investor issue. So we can talk about it, substantial investment and all this. We did talk about status versus visa, right? That's clear. So if you have issues with your status, that's a big problem. If you have issues with your visa while you're here. For example, you're opening your passport and you're saying, oh my God, my H-1B has expired. Not so, because your visa may have expired, but if you have the approval notice, H-1B approval notice that say that you in valid H-1B status for another 2 years, that's what your status is determined by, right? So don't be like, oh my God, I need to, like, no, this is visa. Visa is only the way for you to re-enter the United States, right? And you may have to go outside if you travel next time, go to the consulate and extend your visa, right? So you put another visa stamp, H-1B. Your stay in the United States is determined by your approval notice, or by, if it's J1, it's a DS 2019, if it's so on and so forth, okay? So very important to distinguish between these two terms, visa and status. Immigrant intent. Some non-immigrant visa has a presumption of immigrant intent. Like if you get J1 at the consulate, or F1 student visa, or B1, B2, you usually, when you talk to the US consulate, to the consulate officer, you will have to prove that you don't have an immigrant intent, because there is a presumption on immigrant intent, and you need to tell officer, no, officer, I don't have immigrant intent. Here's my documents that I have an apartment or house, I have a bank statement, I have employment, I have an intent to come back. I don't have intent to immigrate to the United States. Some visas do not have presumption of an immigrant intent. They call dual intent. For example, H-1B or L-1A, you can go to the consulate, try to get your H-1B visa stamp. You can say, and by the way, officer, I'm thinking about staying in the United States on the green card, and there is nothing he can tell you, because that's fine, okay? It's okay. For H-1B and L-1A visa, yes. But some visas like J1, F1, B1, B2, they have presumption of an immigrant intent. So, and it's 214B. J1 visa. That's a very interesting visa. There are at least 13 different types of intern and trainees visas. We work a lot with trainee visas. For example, if the company needs an engineer or manager to come for 9 months or 18 months and be trained with them, right? So they pay not the salary but stipend, and they don't employ him. He is signing the host agreement and trainee agreement, host organization and trainee agreement, and he is training at the company for a certain period of time. And again, that type of visa is very interesting, because you are not going through the immigration services, you're going through so-called umbrella organization. So there are certain umbrella organizations that deal with the J1 programs. So if you are interested in getting this type of visa, again, we are working with many of those, and very successfully. So, okay, we went through green card options so a little bit. So EB1 first preference, getting back to element of extraordinary ability. So this is O1 visa progressing to EB11, same criteria, different service center, and the standard is a little bit higher, obviously, because this time you're applying for a green card in the category. You can apply self-petition. This is the only EB1 preference where you can self-petition, like EB1. You can do it for senior research and professor, multinational executives, and manager. For elements of extraordinary ability, you don't need a petitioner. You can tell, not for O1 though, for the green card. You can say, I'm extraordinary, give me a green card for myself. I don't have an employer, but I'll find one because I'm extraordinary. Again, multinational executive and manager, we talked about it. EB1, 3 category. Labor certification application. Does anyone in the middle of this process? No? Okay, there are some. Okay. So employment-based second and third preferences. You can get green card by going through the process that is called labor certification application, or PERM, P-E-R-M. And the first step is to get the certification from the Department of Labor. And to do so, the employer have to probe the American market for willing, qualifying, and available US workers. And what happens, the employer advertises. There are special mandatory means of advertisement, and there is a menu of several that you can choose. You can choose 3 out of 10. And going through all this step, you either get several resumes or 100 resumes or none, and then you have to interview qualifying people. If they're qualified on the face of resume, you have to interview them. If they are not, you have to inquire further, and you have to interview whatever qualifying candidates you have. And if you did not find anyone, if no resume came or those who applied are not qualified, you can petition to the Department of Labor. Say, Department of Labor, we've done everything and we can't find anything. Definitely there is not a qualifying candidate for this position. Please certify our application. And then the labor certification application happens. With this paper, the employer goes to the immigration services and file the immigrant petition in category EB2 if the position requires master's degree or higher, or bachelor plus 5 years of experience, on EB3 if it's bachelor or foreign equivalents and less than 5 years of experience, or skilled workers. The EB3 category is backlogged 6-7 years, and so I mean, even if you get the labor certification approved and I-140 approved, you cannot still get your green card for another 6-7 years. EB2 category is current, except for some countries like India and China. Okay, the whole process takes 1.5-2 years. There is such a process that's called audit. 30% of the labor certification cases are audited, so in this case it takes even longer. Okay. The important thing is that if you're an H-1B non-immigrant visa, and which is only for 6 years, right? And you filed labor certification application per firm 365 days prior to the expiration of your 6th year of H-1B, you can extend your H-1B indefinitely. Okay, because immigration says, okay, well, since the your process for the green card is still going on, meanwhile, we'll extend your non-immigrant status, which is very generous of them. Same if you have I-140 immigrant petition approved, and if your priority date for some countries like India or China in the second category is not current, and you have this process going, labor certification application, or I-140 approved, you actually can extend your H-1B for 3 years, in 3 years increment, which is very convenient. Okay. EB4 religious worker visas, EB5 $1 million investor green card. We do those. We work with regional centers.
I have a question.
Yeah.
Regarding the extension.
What's that? Okay. Yeah. Go ahead.
If your 140 is approved,
Uh-huh.
and let's say you transfer to another company, and that H-1B will it be issued? Can it be applied for 3 years?
Yes.
Or it has to be for 1 year?
No.
It can be applied for 3
If
years.
your priority date is not current,
Okay.
you have I-140 approved,
Okay.
you can apply for extension of H-1B beyond the 6th year for 3 years.
Even if I change the employment?
Even if you change the employer.
Okay, thank you.
Okay. Here's another options we talked about briefly. Green card lottery, family-based immigration visas. We do those as well. Again, you can apply through your parents if they're U.S. citizen, marriage, or if you have adult child more than 21 years old, which I don't believe is the case for anyone here. Mm-hmm.
This is just, why don't they exclude siblings? Let's say your brother is an American.
No, they don't. They don't. So this is the immediate. Okay, so that's detail, but definitely no. There are 4 other family-based categories, but they're not immediate. They have waiting period, right? They are backlogged, and there are priority days. So there are category, and the brothers and sisters of the U.S. citizen is the 4th category, and it's backlogged 10, 15, 18 years for some countries. So you can apply, but it's not going to have. It's not an immediate relative. The immediate relative of the U.S. citizen are spouse, parent, or if you're a child, it's going to be after 21, you can apply for your parent. That's how you can get, right? So, but if you are not a U.S. citizen, if you're a green card holder, you also can apply for your spouse and your child, and that will be a different category, 2A, 2B categories, right? So there are unmarried sons and daughters of U.S. citizens, which is also another category. But again, all those other categories, they are backlogged. Okay? And
Just never understood the logic behind. Okay. Anyway.
okay, yeah.
That's a family-based. that's not
Family-based,
purview
exactly.
of yours.
Yeah, and there is a visa bulletin by Department of State every month. It's updated every month for priority dates. So you can see those numbers are not moving. So 11 years is 11 years, and 9 years is 9 years. But again, I mean, it's a lot of people. I mean, immigration has a lot of work to do. That's our email address, our website, and phone number. We are, again, in downtown Palo Alto. I can go back to our address, and I will be happy to look at your resumes.
Quick question.
Uh-huh.
What are you said regarding the criterion for H1B, filing H1B? Is it applicable for H1B transfers also?
Absolutely, same, yeah. There is no difference between initial filing H-1B, transfer, concurrent, part-time or full-time, new office or big office. There is no difference. There are guidelines that change every year, and it's not becoming easier. It's becoming harder and harder. Like, for example, we were fighting marketing analysts before. Now marketing manager, questionable specialty occupation. So it's not getting easier. It's getting harder. But it's still doable, and thank God.
So are we out of the general questions?
I think we're out of the general questions, right? So let's.
is this the general question?
Sure. Yes.
I believe we kind of rushed over the E1 and E2 visa categories.
Which one?
The E1 and E2 visa categories.
Exactly.
Is there something like a rough amount or a minimum amount of money that you need to invest in the country? Did you discuss over it?
No, because usually E1, E2 is not the most popular type of visas discussed in this. People usually talk about L1A, H1B, J1, O1. There is no, again, from my experience, the minimum amount will be 150, 200,000. It depends on the country. I've done 130 in Frankfurt, but that's usually the lowest amount for E2, for investor visa.
So you have to invest $100,000 in a business in the US.
Correct.
And will you have again a scrutiny at the end of 1 year to show that you have 10 plus employees?
No, there is no 10 plus employees. That's for EB5.
Uh-huh.
And again, there is no 1 year or 5 years. It depends on the country. Some countries like Ukraine have E2 for 3 months only, and you can extend it for only 3 months. Some countries has 5 years E2, so there is no scrutiny in 1 year. Does it make sense? It's very, so the E1, E2 visa are very country specific, so to speak, like period of time. There are general terms of arts and considerations, and I'll be happy to talk to you about several issues of principal investor versus essential employee, for example. There are different types of E2 visas. So, I mean, which one exactly you're interested in, we can talk in person.
So 100,000 seems to be like a pretty small amount of money for anybody to come from a different country and invest in the US.
You'll be surprised, right? It's not the only thing you need. You need a very good business plan. The money has to be at risk. The investment cannot be marginal. There are a lot of things. This is a very general statement. You can have 100,000 and invest and you think you can get a visa. No. There are a lot of considerations, and we can, like I said, I can.
I'd love to talk about that sometime.
Exactly. Yes.
So,
Why is the
yeah, so I have one question. So you said you can't self-sponsor your concurrent H1B, right? You need to have a board of directors, correct?
Correct.
So do the board of directors need to be US citizens?
No.
Okay.
No. Anyone.
And another question regarding concurrent H1B. Let's say you're with an established company, your I-140 is approved, and you have applied, I mean, you've got a concurrent H1B. So when you move to the other company, let's say you make the switch from the established company to the startup.
Okay, yeah.
Can you just carry on your green card process from there, or does it get reset by any chance?
It depends. It depends on what stage of green card process you're in.
That's what I'm saying. Let's say the I-140 is approved.
You can carry the priority date, but you cannot carry the green card process. I'm not sure.
Is it possible, is it typical for these,
You can.
for the startup to apply for, I mean, does it get approved?
It's very difficult. You know why? Because there is the ability to pay the preferred wage, which startup probably will not be able to prove. That's what makes it difficult, right? So when you can move your green card, so-called, right? So the whole petition, the adjustment of status application has been filed, and it's been pending for 180 days. Then you can move to a different company, and it can be your own startup or some other company, as long as the same occupation or similar. Okay, but before that, you will probably lose your green card process. The only thing you will not lose is priority date on your I-140, which is important that if you are from the countries that priority date are backlogged, like India or China, then it's important to keep your priority date. So then you're not losing anything, okay, so to speak. Okay, are we in the still general question mode? Okay.
Category.
Okay.
So just adding on.
Adding on to what he said, so the company which is sponsoring your concurrent H1, does it need to physically exist, or does it, can it be a home-based business?
No.
No.
It
Okay.
cannot be home-based.
Okay. All right. Okay.
It has to have it has to have an office. It has to have a business plan. It has to be a real company. And home-based businesses, no. It's a bad idea. Yeah. Okay.
Oh, right. I completely forgot what I was going to say.
That's okay.
I can actually add to that question. So, you said earlier that single person cannot open the company on a concurrent H1 visa because he cannot fire himself technically. But then
There is no employee-employee relationship. So
Right.
yeah.
But then three H1 people can open a company on concurrent H1 visas, because at least they are 3 people, so they could be like.
Right. Of course.
So you don't.
Yeah.
Okay.
They can. 2 people can.
2 people can. Okay.
All right. But you have to have a board of directors with 2 people, because one of you may own the controlling.
But let's say both
interest.
of them are 50% partners.
That will be. We need you need a third person to have a majority when you're voting for somebody's performance, firing someone, hiring someone. I think we are going in a very technical issues. I
One
think.
last one.
Yeah. Okay.
So I was just going to ask about the labor certification.
Uh-huh.
Can you just give me a basic idea of how involved that has to be? Like, do you have to search from coast to coast, or is it just search locally?
The employer, you mean? The employer?
The
Yes,
employer,
it's
when they have to prove
yeah,
that.
it is locally. So, for example, you give give a printed media ad, and it has to be a newspaper of general circulation of certain area of the employment, right? So, for example, if you're in New York, you cannot put the advertisement in San Jose Mercury News. But if you're in San Mateo or Santa Clara County, you can. You can actually use 2 newspapers, San Jose Mercury News or San Francisco Chronicle. So it's local. So and again, it's if you go through the means of recruitment, there are some geographically specific. But if it's online, it's online. It doesn't matter, correct? So like it's online. Or if you do it on company website, again, it's digital. But if it's a printed media, that has to be local.
And is there a limit, like minimum number of people you have to interview, or minimum number of days you have to wait? Or
Yes, there is a regulatory period. For example, Cal Jobs in California, you have to post your ad. The posting has to be on the Cal Jobs, that is the EDD website, Department of Labor, California, and it has to be there for 30 days. And then the waiting period, regulatory waiting period, is another 30 days. And you have to do all other means of recruitment within this period of time. So it's very tightly regulated by the Department of Labor.
And you have to prove that why you've rejected all the candidates.
Absolutely, yes. Correct.
Thank you.
Mm-hmm. Pleasure.
So I have an H1, and if my startup files another H1, a concurrent H1 for me, does it need to be in the same skill set job category?
No.
So I can be a mechanical engineer and I can do a startup in software.
Right, if you have qualifications, right. You will have to prove to immigration services in this case that you have the qualifications to be a software engineer. If you have a mechanical engineer degree and no experience, you cannot prove that your specialty occupation is in a specialized field. For example, you can't have a bachelor degree in puppetry, right, and be a software engineer. It has to be related.
You just killed my startup.
Well, do you have enough years of experience doing software development? Because again, it doesn't have to be a bachelor degree in computer science. It can be, for example, listen, maybe we'll just reviving your startup right here. So you have a bachelor degree in engineering, right? Like, I don't know, like electronic engineering, right? Which immigration services may say, no, it's not exactly computer related, right? So, but you have 6 years of related experience in software development. And 3 years of experience equals 1 academic year. So if you have that bachelor degree in engineering, right, and 6 years of computer field, then I can send this to evaluation services, and they will give you the equivalent of a bachelor degree with double major, engineering and computer science.
Got it.
Thank you. Thank you.